started. Good afternoon, guys. Thanks for joining us on this month. So Now You Know with Legalese. My name is Christian. I'm going to be hosting today's talk. Let's just get into a little bit about us. So if you aren't aware of our services, or perhaps you've worked with us before and are aware, but let me just give you a little bit of a background as to who we are. So Legalese is a creative legal agency. We have redesigned our legal services in a way that suits the creative, startup, and tech-based businesses, whether they be just starting from the ground up or they've grown into a global international space. We are there to assist them and help distill and translate a lot of the legal jargon and complex frameworks that they themselves interact in their businesses. Let me tell you a little bit about myself. My name is Christian. I work in the commercial side of Legalese, specifically with our creative clients, and that can span cross industries. So a lot of my work can be with the screenwriter or the production house. It can be with the artist who is commissioned for work with brands overseas. It can be with agencies, or it could be with influencers. There's a wide range that we get to interact with, which is quite an amazing experience, I must say. Legalese prides ourselves in being part of a community. We like to be integrated in with our clients and understand their businesses and their clients so that we can give the best support possible. One of the ways to do that, and one of the best ways to do that, is to be active in those communities. And that's why we do these talks, right? It's so that we get an opportunity every month to share something with our clients and their clients and whoever gets logged onto these talks, so that they can be empowered to understand a specific aspect of it. So today's topic is tips on protecting intellectual property. Now, that seems quite broad and maybe needs further explanation, but what we will specifically be dealing with today is what is my role, or what is the role of your other friendly lawyer that you may have? Who are the parties involved, right? So when you're dealing with these rights, how are they interacted? Sometimes these rights are bundled together, and there's collaborations and there's lots of people involved. So it's very important to identify them. What are the types of intellectual property? There isn't a singular type. Intellectual property is this broad category of ethereal rights. These things that are not necessarily tangible. They live out there in the ether, but we understand them to be rights that allow us to have control over a specific property. And we'll discuss those types. And then you'll see there's kind of a focus on copyright. The reason for that is, as you'll know later when we explain it further, is that copyright is something that happens automatically, and it's a right and protection that everyone should be aware of, and I think a lot of people aren't. So you'll see that we talk about the effects of copyright, the types of copyright, exceptions to copyright, and that's because this is something that happens automatically and everyone should be aware of. But as we go further, you'll see we discuss multiple jurisdictions and the consequences that may happen in those spaces, the differences in terminology. In America, one thing may be called one thing, and in South Africa, it's definitely called another, but referred to in similar frameworks. And that's important for us to discuss. And then at the end, we'll discuss how to deal with contracts. So, if you don't have these automatic rights that happen, if you haven't registered your rights, how exactly are you going to protect them? And there's a lot of contractual remedies that we can go through. And then hopefully there will be some time for questions. If we don't get time for questions, you can always email us. I'm very happy to answer that way. We all are here at Legalese. So cool, let's jump right in. What is the role of a lawyer? Now, I think this is something that isn't necessarily finite. You could find a lot of different answers to this question. But for the purposes of today, and for the purposes of empowering you to understand your IP rights and how to protect them. I think this gives a good purpose for why a lawyer should be involved. They view things as a composite whole. There's a lot of moving parts when it happens to intellectual property, and it's good to have eyes that see things in a big picture space and can understand the moving parts of that space. A lot of times what I say to clients when it comes to contracting is that the benefit of a contract is the opportunity for a conversation, right? So lawyers get to facilitate the conversation of those parties involved. So whether it be, the person who had the idea for the screenplay and the production company that wants to make it happen. And maybe there's a writer that they are going to include to collaborate on that space in revision. So facilitating that conversation and distilling it into a contract is a very important role of a lawyer, and definitely one that benefits everyone involved. We often end up being the worst case scenario people in the room, and that's not necessarily a bad thing, because it's part of that risk analysis that you need to do, right? When you're contracting, or when your business is dealing with intellectual property and how it moves from one party to the next and its usage, it's very important to understand what is the worst case in that space and what is my risk. And lawyers are good at doing that. And then lastly, I've bolded this and underlined it because that's today's goal, and that's my role for today, is that we are here to educate. Sometimes it's easier than others, right? I'm not going to be able to give you a law degree by the end of this hour, but what I may be able to, and I hope I'm able to do, is at least give you some language that you feel more comfortable with, that you then can navigate. And if you can't navigate, you at least know to go to your friendly local lawyer and find the assistance that you need, and upskill again further in your understanding of that area. So let's talk about who are the parties. Now, this can be really complicated, right? Because you get people who have the idea, then you get people who finance that idea into production, and everyone sometimes wants pieces of the pie, and you have to kind of figure out where everything flows and identify who gets what. Sometimes it can be very simple, but as you know, or maybe you don't know, and you will find out, law can be incredibly complicated when it wants to be, and sometimes wholesomely simple. So let's talk about these rights, the variety of rights. Just some tips that I think are really important is you have to identify who the creators are. And as we go on further to discuss these different types of intellectual property, I think it'll be very clear as to why that is important. The existence of licenses is very important, right? So you may find the creator, but the creator has licensed these items out. And for you to understand what rights you hold when you engage with IP, you need to understand if the creator has licensed them out. And if you're the creator, you need to understand your ability to license out and carve out specific usages for those IP and restrictions on those usages. Again, these are terminology that may be uncomfortable for you because you're not a lawyer, but having a general understanding of it definitely empowers you to at least navigate your way through in the beginning. And then when it gets too complicated, come into your lawyer. So who holds the IP rights? It's not always the creator, right? So sometimes the creator has sold those rights off and assigned them to a new person. So it's important for you to follow the trail beyond, maybe it's not a license, maybe it's actually sold off. So that's important. And then, if you are creating something and it has other IP involved in it, it's always important for you to attribute the creators of other IP, but the end all be all is that a original content preference, right? And that's because it's the cleanest, simplest way of engaging with IP in that space. So let's talk about the legal side. Now, this may feel a little bit lectury, but I'm going to try and keep it from being too lectury. There are 4 main types of intellectual property that we're going to discuss. And those 4 have their own nuances and complexity to them. And I'll briefly go over them in a general sense for you. Some are more complicated than others. So you have your patents, you have your trademarks, you have designs and you have copyrights. Now, I've already told you that we're going to focus primarily today on copyright just because it functions automatically and the rights happened at creation. And we'll discuss kind of like the nuances in those spaces. But I do want to touch on patents and I do want to touch on trademarks and designs. They are all very important, specifically for the creative industry, right? So let's talk patents. Patents are an exclusive right granted for an invention, which is a product or process that provides a new way of doing something or offers a new technological solution to a problem. So the important things here to remember is that it's new, right? That this invention has not been made before and that it has a new solution for a problem or a new way of doing something. And because of that, it gets the right to be patented. And the person creating it then can proceed to do so. And what's important here is that these patents require applications for registration. They may require multiple registrations or applications in various countries, depending on which country you're looking at. So you'll see here that I briefly mentioned the Patent Cooperation Treaty. There's 148 countries in this treaty, and you may find that there's international cooperation between those parties and some type of formalization internationally with regards to the registration of patents. Generally speaking, it's an up to 20-year protection, which is renewed annually. So let's talk about trademarks. So trademarks, you'll hear them very often, and they often get kind of tied up in copyrights for people's understanding that they are separate. They specifically deal with brand names, they deal with slogans and logos. Here, I think I've used the example of Coca-Cola just because it's one that everyone knows, right? The name, the logo, bottle shape, these have been trademarked and protected by Coca-Cola. Trademarks identify the services and goods of one person and distinguish them from the goods and services of another. And that's a really good base of trying to understand the differences here. They are there for your brand to distinguish itself as an individual brand in and of itself and not be confused with a competitor or a brand with a similar logo, name, slogan, but different, right? You want to make sure that it's distinguished. And that's what these trademarks allow you to do, is protect from too similar, protect from identical brands doing what you do. And this protection is perpetual, right? So the beauty here is that you can continually renew it every 10 years and that you do get these rights without an expiration date, which, as you remember, patents didn't have, right? So let's talk designs. Designs are very interesting because they get broken into two different spaces, the aesthetic design and the functional design. So some designs are necessitated by functions and others are aesthetic, right? Design about the shape, form, pattern, ornamentation, configuration of a product or an article. So if you think about that, jewelry is a really great example. The way in which it's configured, is it aesthetic in its design or is it functional in its design? And if it is original and new in either of those categories, then it may be potentially open for protection under design in intellectual property. And I think the thing to remember here is when it relates specifically to the aesthetics or the beauty of a design, or when it relates to the function. So a zipper would be a good example. If there's like a new way in which a zipper has been reinvented and designed for its beauty or for its functionality, then that could be something that could potentially be protected. Copyright. Now, we're going to spend a lot of time here, as I already said a few times, but copyright is an exclusive right that's granted by law for a limited period to an author, designer, creator for an original work. Unlike other forms of intellectual property, copyright does not require registration. And that's why we're spending a lot of time on it today, because the way in which you protect your IP is first by understanding if your IP is automatically protected and what those protections are. And that's why we're going to spend some time in these types, their effects, and their exceptions. Generally speaking, you're going to get a 50-year protection here, but you'll see that that's not actually true. It's a generalization because it's 50 years plus sometimes the life of the creator, and you'll see as we go that can be more and more complicated the more categories you end up understanding. So what is the effect of a copyright? It grants the creator an exclusive right that vests automatically. And that's like huge, right? That's very huge. If you understand that what you've created falls into the categories of copyright, you know that there is some protection automatically granted to you. Now, maybe you don't know exactly what that protection is, and that's because you don't spend every day reading legislation, and maybe you don't spend every day inside the Copyright Act. But what you do know is that my intellectual property automatically gets protection. And that's a huge deal and really important for you when you're running your businesses. The lifespan of this protection, as I said, is generally 50 years, but what's going to dictate it is the type of copyright. So as we go through these rights, pay attention to how they differ and how they function in terms of this legislation. What does this prohibit others from doing? And we're going to talk about later the consequences of infringement in the space. But infringement would be the reproduction of something that is copyrighted, the publishing of work that is already copyrighted without, for instance, the attribution of the creator, or the making of an adaptation of work could amount to an infringement. So having these copyrights protects your work from being reproduced or possibly adapted. Performing the work in public, using the work in an unauthorized manner. We talked earlier about, specifically limiting the uses of your intellectual property, and that will happen, in contract spaces where you've licensed out or you allow for IP to be interacted with. But unauthorized manner means even things that you haven't agreed upon that are in law, that exist as a protection in law, and those are these copyright protections. So let's talk about the different types of copyrights. There's 10 distinct categories that you're going to find in the Copyright Act: literary works, musical works, artistic works, photography, cinematograph, films, sound recordings, broadcasts, program carrying signals, published editions, and computer programs. Now, I'm not going to go into every single one of them, don't worry. I'm just going to try and focus on, I think, 6 of them. I think is a good number that we'll go through. And we'll just kind of go through who's protected in this space, what are their examples, and what is the protection insofar as when does it commence and when does it expire. So let's talk about literary works. Literary works deal specifically with the author, right? It's in the name. They wrote something, and because they wrote it, because they manifested this idea into actual written form, an automatic protection in law is granted to them. And the examples you can see would not just be novels, but they would also include poems. They would include screenplays, as I used as an example earlier. They would include written compositions. And that's because the idea that they had is not one that is protected automatically in law. It's the manifestation of that idea into a written form, right? And that's a theme that we should remember here, is that copyright protection that's granted to you is not one that's granted to you when it's just in your head. It has to do with the actual manifestation, and you'll see those with the examples. So literary works are protected from the time that they are written down for the duration of the owner's life, right? So if you're an author and if you've written something, then you're protected for your entire life, plus 50 years after your life. Interesting. Musical works. So who's protected? Now, this one's quite interesting, and we work quite a bit with musicians or production companies that are trying to get these rights and trying to understand these rights. And remember earlier, I mentioned a bundle of rights. So a bundle of rights could mean the way in which you use that rights, but it could also mean that the right holders are bundled together, right? And in that space here, we're talking about often these works have multiple contributors, multiple musicians, sometimes Sometimes there are people who write the lyrics, and sometimes there are people who write the compositions and the musicians themselves who are contributing to it. Now, it doesn't always mean, you'll see later that there are exceptions to this where it gets automatically gifted to the creator, and that will deal specifically with commissioning and employment, But it's good to understand that these are layered. They are not singular, like who's the author. Although, like I said earlier, if, for instance, a screenplay is being put into production and part of that agreement is that there would be collaborating authors, then the people with the rights that have the rights automatically granted to them may be multiple in that space. So it isn't, again, as simple as that previous example. So musical works are protected from the time that they are written down, composed, or recorded. Now, let's go back to that theme of an idea being manifest. So at this point, when it's written down, when it is composed, or when it is recorded, is an action for which the idea has been manifest into real form, and then real form has been granted automatic rights in terms of the Copyright Act. And you'll see that again, and this happens a few times in the Copyright Act, depending on the type, is that the owner or the creator is the duration of their life is the duration of the protection plus 50 years after their death. So let's talk about artistic works and photography. Now, these are two different categories, two types, but I wanted to bundle them together because I want to show you how these two function differently insofar as the duration of the protection. Now, both of them have the same thing. The person who is protected is the creator. Now, be careful because we're going to discuss this later with regards to the exceptions, but this category in particular, artistic works and photography, are often participants in commission relationships. And those commission relationships may amount to or do amount to exceptions in this protection. So what are the examples? Artistic works could be paintings, drawings, or sculptures. Remember, the theme here is the manifestation of that idea gets you the protection that you're looking for. And in terms of artistic work, it may take the form of even a sculpture. It may take the form of a painting or a drawing. Only in those spaces, when it comes into the physical form, does it get that automatic protection. So let's talk about the protection that's granted, when it commences and when it expires. Now, previously we were talking about the life and when it gets broadcast or when it gets recorded. But here, for instance, it's from creation by the owner for the duration of their life, similarly to literary work, right? So it's from creation. For the photography, it's from development. Now, that's different, right? So it's not from the actual taking of the photo, but it's from the development. It's from the development of the photograph for the duration of the owner's life, plus 50 years after the death. Now you can see how, as we go, this is getting slightly more complicated, and it's important to understand that your intellectual property may fall into this category, but it's not clear exactly what the protection may be unless you dive into these specific types, right? So the first step is just knowing what your IP falls into category-wise, and then if you have the time or if you have the friendly lawyer, finding out exactly what the duration of that protection is and when it commences and when it expires. So let's talk about films and sound recordings. I find these to be quite fascinating, right? Because it goes back to who's protected, the creator, and that's quite simple. But then the person who makes the arrangements for the film and the sound recordings are the creator in that space. And if you think about all the people that are into play of this production and creation of these works, it isn't just a singular person, right? So if you don't have contracts that facilitate how this works, the default position could be very confusing. And that first question, that first part of the exercise of who are the parties could be a very complicated one and a very time-consuming one, and everyone may have a different opinion as to who holds what. So the protection in terms of film, right? It's for a period from the date the film was shown, which is very interesting. Similar to the sound recording. It's from the date from when the recording was first broadcast, and that's for a period of 50 years. Now, you'll see here, there's no mention of the lifespan of the creator. In this instance, it is a singular time that has been dictated from the broadcast or the sharing of that IP to a public space. I've mentioned these a few times now, and I would love to dive into them with you because I think this is where it can be very important for you and your business to understand how those rights work and where there are exceptions in those rights. Because perhaps you aren't the artist, but you have hired the artist to do something for you. Maybe you are the graphic designer, but you've been hired to do so. And it's important to understand what rights you have and how they flow, because perhaps you're sitting here thinking that the work I do is an artistic work and I have these rights that go beyond me, but you fall into a space where this is an exception. So the sale or contractual assignment. Now, these are they're not that simple. What ends up happening is the right that's held by the creator gets assigned to a new individual through the process of a sale or through the agreement between, and I keep going back to that screenplay writer who's going to make his screenplay into a television series or a film, may then assign specific slices of the pie to his intellectual property to other parties in agreement to get the actual work produced. There are many ways in which this can be done, but it's important to know that by contract, you can end up in a space where there's an exception. So the owner in that space becomes the person who's accepting the sale and assignment, and not the original creator. So let's talk about employment. And I think this is a really important one, right? All work that's done in the course of employment under the contract of service or apprenticeship is owned by the employer. Now, why is that important? Well, it's very important because people, knowing that they are creating, may, now having heard this, think that they get this automatic rights. But the reality is, if you're in a space where you're employed, or if you are the employer and you have people working for you who are creating these works that get protection, it's important for you to know that the rights do not sit with the creator in the space, they sit with the employer. Also, I just want to go back to the employment space. So if you think about agencies where they have clients that they're creating work on behalf of, now they have agreements with their clients that the work would be owned by the client, right? And we're going to talk about now when there's a commission space. It's just important for you to also understand that there's no contradiction in that the creator getting these automatic rights, because if that creator is employed and then their employer is commissioned, it makes sense that the rights would then flow back to the eventual right holder, being the end client in that space. So commissioned work, and I think this is one that people are kind of aware of, but not necessarily always aware of. And you'll see that, some agreements. So say, for instance, you have a photographer, and that photographer has been hired to shoot your wedding, right? And they want to hold specific rights to promote their work on their socials, on their sites, and they want to limit the use of your use of those photographs to personal use and not to commercial use. So you might find that in a contract, despite this automatic exception here, there is a relationship that is intended between the parties, and it can be complex and not have this automatic assignment of rights. So frequent examples you'll see are photographs, paintings, drawings, films, sound recordings. Now, the owner is the person who makes the payment for the commission work, and it is not the creator. Now, payment is one of those vital aspects of this transaction. So what ends up happening is, say, for instance, you are a programmer and you've been hired to program a website for a client, and the work that you've done for them has been made live and payment hasn't happened yet. The way in which that ownership transfers hinges on the payment made for the commission service. So these will often, again, be clauses in agreements, hopefully, if you have good lawyers who are assisting you. This is also where it needs to be, you need to be careful when you're trying to save money by using Google as a lawyer, because not understanding these clauses could result in some pretty bad consequences. And actually, let's talk about those consequences that you may deal with. So when you're dealing with multiple jurisdictions, and specifically for something like this, where the property can transfer from one continent to the next quite easily. It's not like a house, right? It's not something that's rooted in the ground. It's property that can move, faster than a car can, because it can be sent easily digitally, and infringement can happen quickly and can grow into a huge space of infringement with multiple infringers. And it's important for you to understand what the jurisdictions see. So one issue or struggle that you might find is that there is an absence of international copyright law, right? So these laws are territorial protections by their nature. But the reality is, as the example that I gave you, infringements are often extraterritorial. And by that I mean, you're going to end up finding people that are not inside the same jurisdiction as you, that may be in different countries than you, infringing on your rights. And you want to understand how to enforce your rights, or how to stop them from infringing further against your IP. And that's where it may be very complicated, and I definitely advise you in not using Google and relying on Google there, but actually finding the time to sit down with the lawyer and explain the situation so that they can go through the nuances with you. And just as an example, I've given 3 jurisdictions here, right? So we have South Africa, we have the UK, and we have the US for infringements. Now, protections are based on category in South Africa, and we know that, right? Because we just gone through all those categories. You guys are well aware that there are specific protections that fit for specific categories, and they don't exist in the same way, they don't endure for the same way, and they actually don't land in the same just creator space. They can be more nuanced than that. But generally speaking, right, we see that there's a theme of the life of the creator, the life of the author, plus a 50-year space. But if we're looking at literary works, just literary works, here it's the life of the author plus 50 years. But in the UK, it's the life of the author plus 70 years. And then if it's an unknown author, if the author of a literary work is completely unknown and anonymous, then the protection given to that literary work is only 70 years. In the United States, it's similar to the UK insofar as the life of the author plus 70 years, but it also has this space of from publication, 95 years. Now, just in that one category, and you can imagine that if we were to go through all of the categories in South Africa, and we were to compare them to the different jurisdictions, then it may end up in a space where it's very confusing, and you won't be sure on how you may enforce those rights. So that's another reason why you need to ensure that you have the assistance of people who understand navigating legislation that can be quite arduous. So let's deal with the consequences, right? So if we were in those spaces and we didn't understand that the literary rights to specific works in America had a 95-year period from publication. And we thought it was, the life of the author who died young and 50 years post their death. So let's say we're in this 70-year space and we amount to an infringement because it was 95 years from the publication, right? What are the consequences in that space? So in South Africa, you're going to end up with a fine of up to 5,000 Rand. You're going to end up with imprisonment up to 3 years. You're going to get a second conviction with a fine up to 10,000 Rand and possible infringement of 5 years. And you're going to get things we call interdicts, where people are applying to court to stop you from continuing these infringements and trying to prevent you possibly from doing further or new infringements. And that obviously has consequences insofar as legal costs that you'll have to carry yourself and costs that may be assigned against you if you were to lose. So let's talk about the United States. Now, specifically with the United States, you'll see that these are punitive. So they range from $200 to $150,000 for each work. And you can imagine that in a singular work, there might be multiple intellectual rights that are being infringed upon, and those numbers can escalate quite quickly. Now, injunctions are kind of similar insofar as they are intended to stop you from further infringements. So similar to the interdicts that we're speaking about in South Africa, in America, you may end up with a hefty legal bill insofar as someone seeks to enforce their rights and therefore seeks to stop you from infringing. Now, I want to focus on wrapping up in this space of what are the tips to avoid this. Now, we've talked about what happens if your work falls within these categories, and those categories then give you automatic rights. Now, that doesn't mean that you shouldn't be contracting, right? It doesn't mean that, okay, I have this right and it's all good and I can do whatever I want. What it means is that you now understand you have a right, and you want your business to interact with those rights. Your business is clearly interacting with the transaction of those rights. So those contracts should then speak to them. So what should you look out for? Now, there has to be a consideration of the matrix of how these rights move, right? And that could be, who's the creator? Has the creator sold it? Has the creator licensed it out? Is it even the creator who holds the rights? Is it the person who made the arrangements? Is it the person who arranged the film and directed that film? You want to look for worst case scenarios. When you're going into those contracts, make sure there are those dispute resolutions. Make sure there are spaces where if there's a breach, you understand what your rights are. Now, in copyright, we've just discussed that you have intellectual property rights that are automatically protected if they fall into that category, and then you can enforce it. And you can enforce it by demanding that people stop the infringement of your right. Now here, if you have a contract, then you have contractual remedies in addition to those, right? And that's a much better space to be in. You want to be able to protect yourself and your business and your intellectual property as much as possible. So adding these contractual remedies is one that may seem tedious in the beginning. I know that sometimes I'm that person in the room that is playing worst case scenario, but trying my best to make it not too tedious because it's worthwhile in the end, because you need to have the foresight of what is going to protect your business, what is going to protect your brand, and having these things in place is that first protocol for protection. You're going to want to look at how the IP is dealt with. So if we go back to the complexity of creating a song, you're going to end up dealing with the IP rights in multiple collaborators, possibly if they weren't commissioned individually, and if they want to hold the rights and have a part of that pie. If you're dealing with the screenplay being put into production, then you're going to end up with multiple hands on the pie again. And you're going to need to understand how that IP is dealt with. So is it dealt with in a way that they license out to distributors? So distributors are allowed to broadcast it on various platforms. That's something that you're going to need to look at. And that's not something that's very simple. And sometimes it can be quite a needle in a haystack when you're looking at a contract. And then obviously jurisdiction, right? Jurisdiction, we just talked about, given some examples, the variety of how these rights function and how they live is quite vast, right? There's similarities you see even with the UK and the US when it came to that literary work example. There's that 70 years, but the reality is America had the publication nuance, right? So they had that 95 years from publication. And if you don't look at the jurisdictions and you just look at the space of where you exist and where you're creating, so say you're here with us in Cape Town, or say you're here with us in South Africa, then the jurisdictions that you default to are the South African jurisdiction. But as we discussed, these rights are rights that experience extraterritorial infringements, right? So they go beyond the continent or beyond the country that it's specifically in, and they end up needing to have people who understand how to enforce those rights and what those rights are in those countries. So this is the basics that I give to everybody, and I think it's really important that good defaults doesn't just have to deal with IP, but it does specifically work with IP, and it's one that I hope is a takeaway for everybody. When you look at a contract, you need to look at what do you get? What do you get out of this contract? Is it giving you anything? And if it is it clearly giving it to you? Is it accountable? You know, we talked about, is there space for the worst case scenario in a dispute? How does it get resolved? It must be accountable. The parties must be accountable. And if it isn't, you're in trouble because you need to figure out how to enforce it, right? So is there a way to see if what you get out of this contract is measurable, one that can be recorded, a space where you can see whether it's happening or not? And if it's not happening, how do you enforce it? And you're going to want to have those clauses very clearly set out. I can tell you from my experience, they're not always clearly set out. I spend quite a bit of time translating. I feel like translating what the contracts may say, especially if you're dealing with jurisdictions outside of South Africa. They might have a different terminology or language than what you're used to. And that's something that, again, the assistance of someone who might know it better can come in handy. And also moments like this where you are engaging with this terminology and you are engaging with this area of law will also help you because it will empower you to deal with contracts in a better way. So what are the type of contracts that we're going to look out for? And this is kind of my last little bit before we go into the questions. I want to get your head around the idea that these rights require, in terms of copyright, the manifestation of these ideas, right? But that doesn't mean that you can't protect yourself otherwise. You could have things like pitching agreements and you could have non-disclosure agreements where they deal specifically with things that haven't come to manifest yet. They haven't found physical form, but you want to protect them. And you are only disclosing or you only sharing for the purpose of a pitch or for the purpose of collaboration or for whatever purpose. You know, you have the right of recording what that is. And, you know, early on we talked about the benefit of a contract being the facilitation of a conversation. And this is one of those moments where facilitating that conversation is golden. It protects you beyond what the law would have done automatically. And that also goes with licensing, right? So if, for instance, you're that photographer and you want to make sure that, you know, you've been commissioned for these, but you want to limit the use. And so you want to say that I can use it for my commercial purpose, I can promote my services, and you can only use it for personal services, then you will end up in spaces where there are licensing clauses or licensing agreements that deal specifically with the limitation of that use of the IP. Now, I want to talk about also just clauses specifically. So you'll have agreements that don't even deal with IP. You know, the intention of those agreements is to facilitate a totally different relationship. One of which, the perfect example is employment or freelance. So the whole point of that agreement is to facilitate the work that's going to be done, the appointment of that freelancer, the employment of that employee. It will deal with leave, it will deal with sick leave, maternity leave, parental leave. It will deal with salary, it will deal with how a freelancer invoices you. But inside that contract, you can have confidentiality clauses which deal specifically with the IP protection rights of the company. And that has to deal with information being shared between the client and the employee or the freelancer, and ensuring that it's limited to a confidential space. Let's talk about just quickly the nuance here. So you can limit that protection to a territorial space where it's not necessarily limited, or it's completely free to do as much as you want in a specific area. So you have the right to use this IP and do with it as you will to promote my services or my brand in South Africa, or in the continent of Africa, or in Europe. You can tailor these things to your intended services and to what suits your business best. And I think it's important to know that with territory. I think it's important to know that with the duration. Maybe you don't want to give the rights away for too long a period. Your business model doesn't permit that. If it doesn't work with this individual or this business, then you want to be able to pull it back and get it back and rethink and recalibrate. Now, we're finally at the questions portion. I know that I haven't given you so much time for questions. But again, as I said, if we don't get to all the questions, or you're still distilling all this stuff that I've given you today, you can always send me an email or send us at Legalese an email with your question, and we'll definitely get back to you in that regard. I hope that this has been useful for everyone. I'm going to just see if there's questions here. Cool. We're good for now. I'm just going to wait a little and give some people some time. I've really appreciated you all participating in today's. So now you know it's something that Legalese really enjoys doing. And I know that I particularly enjoy doing. And I hope that you've left today with a wealth of knowledge. And hopefully some questions and ideas about what you can do for your business. Cool. I think there aren't any questions. So I'm just going to leave it at that. But again, I said, if you have any, or you think later after you've had lunch, I wish I asked Christian this, feel free to shoot us an email. Thanks, everybody.